get to trial, you need to flip that focus. Ultimately, the liability that you have to establish is the defendant's. So I'm a very strong proponent, 99 times out of 100, you put the defendant on first. You put the defendant's conduct on trial. And even if you don't have a real evildoer, you get someone who's going to talk about the policies of the company that you're going to be, if they raise the Farragut defense, you're going to talk about and punch holes through until the trial is over. Now, there is, some difference of opinion, not as much as before about that, because you are, especially if you have a plaintiff who has some problems in her case, and some things that you don't want to come out, especially from the, in the least advantageous way from the defendant's mouth first to the jury. That's something to consider, but I think most times it just outweighs the benefit that you're going to do yourself in telling the story. And the story ultimately is not about what happened to your client, and it's not about gaining sympathy for your client, because ultimately, remember, the jury's going to get a charge at the end of the case that says sympathy isn't what counts, it's the factual count that you saw come off the stand. What's great about focusing on the defendant is that you're ultimately telling the story of this could happen to anybody. With this egregious conduct in this workplace that allowed sexual harassment, that allowed this person who had great power over this subordinate to wield that power in the most offensive way, that's why you have to find against the defendant, because if it wasn't for my client, if it wasn't my client, it would be somebody else. So I think that's critically important, and I welcome opinions on that. So my question to you